It used to be that lawyers held all of the legal information. We were surrounded by this fortress of information. And even if you wanted to participate in your case, even if you wanted to play a significant role or make your attorney's fees a lot less, you couldn't. But things have changed now. And every time we Google something like filing for divorce or help with eviction, there is so much information out there. Some of it is incredibly reliable and helpful, and some of it is just crap. But for the most part, if you need something, if you have a legal question, you're able to find the information that you need. The question then becomes, can you process it? Can you implement it? Or do you need a little help along the way? Now, a lot of people come to me and they say, I got all this information about what is community property or marital property or separate property or how to calculate support or how to divide retirement accounts. But that's exactly opposite what my spouse and I want to do. We already have an agreement, and that agreement around property or support follows the way that we handled our finances during the marriage. And while we didn't have a prenup, we also don't really like the default laws in our state and therefore want to come up with our own agreement. Can we? Will a judge sign off on our divorce judgment if our agreement is different than what the law is? That's a really, really good question. And the answer is, it depends. No, I'm just kidding. You're so sick of hearing that from lawyers. The answer is usually yes. You don't always have to follow the letter of the law. However, you have to demonstrate that you understand the law, that you are coming into this agreement knowingly, that you understand it, that this is voluntary, you aren't being coerced. So you understand the law, you're waiving out of it, and you've now put together an agreement that follows exactly what it is you and your spouse want. And that should do it. On occasion, a court might want something more. So if you're waiving spousal support after a long-term marriage, the court may request a declaration in writing that states that you understand that under no circumstances can you request support at a later time, and that you declare yourself supporting. Other times, a court might want you to come in for what's called a prove-up hearing, or to voir dire, meaning to ask questions about whether or not you truly understand the agreement and you want to agree to it. Now, that's your worst case scenario. Most times, in fact, the vast majority of our cases, maybe even 90% or more, we don't have to have our clients provide more information or attend a court hearing. But I want you to know that a court appearance is possible, and if so, that's something that that we or another service can certainly prepare you for. So, summary. If you have an agreement and that agreement is different than what the law says you should do, that's okay. You just need to be able to put it in writing, in some cases justify it, but most often just share with the court that you both understand what the actual law is and that you've come to this agreement on your own volition. Hope that helps.